This is the Senate Finance Committee. We are now on our voting list number 9. It's Thursday, February 29th, and we are going to start with our analyst, Nathan.
First bill today would be Senate Bill 215, which as amended alters the eligible uses of the small minority and women-owned business account to allow for grants up to $10,000 in conjunction with a loan. There's an amendment shown in the reprint before you that was requested by the department, is sponsored by the chair, and is identical to the amendment that was adopted in the House.
Do I have a second? Okay, so Senator Hayes moved favorable, Senator Klassmeyer second, all in favor of Senate Bill 215. Raise your hands. Anyone opposed? It's unanimous. Thank you.
Next bill is Senate Bill 457, which alters the permissible uses of the Equitech Growth Fund within TEDCO and makes changes to a related mandated appropriation to allow for the payment of costs to administer the fund. There is an amendment from the bill's sponsor, Senator Washington, that moves the bill's effective date up from October 1 of this year to July 1 of this year. The House is considering an identical amendment. No.
Senator Washington, second Senator Klassmeyer, all in favor of Senate Bill. I'm not getting. Okay, thank you. All in favor of Senate Bill 457? No opposition. Senate passed, the bill passed unanimously.
Next bill, Senate Bill 634 explicitly authorizes TEDCO, subject to a written agreement, to provide administrative support and services to certain business entities and to receive compensation for those supports and services. There are no amendments, no fiscal impact, no opposition at the committee hearing, and the cross file has passed out of Ways and Means in the House.
Second, who's a second? Come on, wake up. I need a second. Senator Klassmeyer moved first, Senator Kyle second. All in favor of Senate Bill 634? All right, unanimous. Thank you.
Boring. And try to spice up my delivery. Senate Bill 746 removes the September 15th application deadline and December 15th grant award deadline under the Winery and Vineyard Economic Development Grant Program within the Department of Commerce. The bill also modifies the period during which qualified capital expenses must be paid or incurred by an applicant for purposes of calculating the grant amount. There's no amendments, no fiscal impact, and no opposition at the hearing.
Love these bills. Can I have a motion on Senate Bill 746? Thank you. And Senator Mount second. All in favor of Senate Bill 746? It's a unanimous vote. Would be good. You want to do that?
Madam Chair, I move that an unfavorable on Senate Bill 497, Senate Bill 696, Senate Bill 715, Senate Bill 945, and Senate Bill 1070.
We have a motion from Senator Hayes and a second from Senator Washington for an unfavorable on 5 bills. All in favor of the unfavorable. I always love that. Unanimous. Thank you.
Okay. So Senate Bill 178 is a bill that the committee has already acted on. This is the one that related to State Highway and the adoption of a pollinator habitat plan. And the EEE committee was second on it. They put on an amendment that had come up here, but what their amendment does is that it makes clear that nothing in this bill may be interpreted to modify, limit, or interfere with state or local laws relating to weed control under Title IX, Subtitle 4 of the Agriculture article. So that was the amendment that they put on.
Thank you, Senator. And okay, wait a minute. We have a motion from Senator Reedy. Who had the second? Okay. And thank you, Senator Ellis, for your question.
Thank you, Madam Chair. So what does that amendment practically, what does it do as far as weed control? How does it impact the bill? Any idea?
I think the aim was to make sure that the requirements of the bill and in the state highway administration and its plan, that the locals would be able to engage in weed control, for adjacent properties. It wouldn't affect that this bill would not affect the ability to manage weeds, on adjacent properties.
Okay. All right, thanks.
So we got a motion and a second. All in favor? Unanimous, thank you. Right, Senate Bill 534.
Hey, this is a bill that just repeals the Electronic Transactions Protection Act. This is a law that was entered. If you may recall this was from at the request of the Attorney General's office. This was a law that was passed way back in 2001 in the early days of the internet. And there was an enforcement unit. So there were some protections relating to, I think identity theft and the sale of mailing lists and whatnot. And there was an enforcement unit, but the act is viewed as largely obsolete, now that the internet has grown to be much more complicated. And the major enforcement duties are under the Consumer Protection Division of the Attorney General's office. So what the bill does is it repeals this Electronic Transaction Protection Act and this unit that was never funded to enforce it.
Reducing the size of government.
And I believe the House has passed this bill and has already passed the
Is
bill.
that a motion?
I always like to repeal obsolete laws. So.
Senator Reedy made a motion. Do I have a second? Senator Washington has the second. All in favor of Senate Bill 534, raise your hands. It is a unanimous vote. Thank you. I'm gonna skip down to 705 and we'll go back to departments later.
Sure.
We're gonna skip down to Senate Bill 705, Senator Hayes and Senator Lamb's bill.
Senate Bill 705 requires the Maryland Health Benefit Exchange in consultation with the Insurance Commissioner and is approved by the Maryland Health Benefit Exchange Board to submit a federal state innovation waiver application by July 1st, 2025. The waiver application must seek to establish a qualified resident enrollment program and seek federal pass-through funding resulting from the implementation of the program, federal funding, if available. I think if the waiver is approved, the exchange in consultation with the insurance commissioner and is approved by the exchange board must establish and implement the program. So the chair has some amendments that she's offering that would adopt some clarifications that align with what the House put on the bill. This is so on page 6 of 7 of the reprint, this requires the exchange to submit a waiver to establish the qualified resident enrollment program and, if available, seek federal pass-through funding resulting from the program. And then on page 7 of the bill, this specifies more tightly that the program must allow qualified residents to purchase plans. And then 3, the third thing here, this alters the information that's included in this report to the Maryland General Assembly so that the report has to include the number of individuals anticipated to participate in the program, the amount of premiums anticipated to be paid by participants under the program, and if the General Assembly authorizes funding to subsidize premiums under the program, the parameters of the subsidies. I think that there's an amendment that Senator Hershey is offering. And this is under the definition of a qualified resident. So the individual who would be authorized to purchase plans in the exchange. And under this definition, that would mean an individual, including a minor regardless of immigration status, who at the time of enrollment provides proof of residency in the state in the form of a current utility bill vehicle registration, tax return, government issued photo identification, mortgage document or lease agreement, or pay stubs covering at least a 30-day period.
That amendment here.
That was on page 2.
The amendment is what's shown underlined on page 2. So this is an amendment that would establish some documentation requirements for individuals enrolling in the program regarding residency, state residency.
This was a concern that we expressed during the bill hearing about how somebody is considered to be a resident in the state, and we wanted to make sure that we were really talking about individuals that had made an effort, a previous effort to be residents of the state of Maryland, and they were not coming in just and being here for short periods of time. So this proof of residency language comes straight from MVA on what they use in order to apply for a driver's license or a state identification card, determining that they are resident as well. So I think it was just some checks and balance to make sure that these individuals are truly residents of the state.
You want to address that? Patrick's gonna tell us what the exchange uses, or is that exactly what they use?
Yeah, so I just was going to speak to what, just for some background. So the exchange uses criteria for verifying residency that's established under the Affordable Care Act. And so the process that they would use for establishing residency is this, for this population, would be the same as what they do for anyone else who enrolls in the program. And so there are some differences in what they accept and what they use to establish residency. So I think that, and so, there's a document that lists the types of information that they use for that. So it is a little bit different than what MVA uses. That was some of the testimony that came in.
Can you read us the documents?
Sure. So for the residency, you have to provide documentation to verify that you're a resident, and they list some items here that you may need to provide: an affidavit of residency, a form DHR FIA 1130 verification of living arrangements. I think it's a federal form. A homeowner's insurance bill, lease, mortgage statement, property tax bill, and a utility bill. I think the exchange, in their testimony, they said they also ping the IRS database to get income statements, which has an address. And then if that's not available, they use the Department of Labor's beacon system for that. So from what I understand is that the processes that they use differ a bit from what MVA does.
Senator Hershey?
Yeah, so when we looked at the I guess insurance through the health connection, it just simply said live in Maryland. So I didn't see what all of that was, be a US citizen or lawfully present. So obviously that's what's being changed in this legislation. And then it said not be incarcerated except if you are incarcerated pending disposition. My concern again, I think, was the response that the exchange provided, that they did look, but I wasn't necessarily convinced that if one of those were not present, that status was still not going to be provided, that there was a pretty extensive list. That I think the affidavit is the one that was concerning on how that might be obtained. So again, we were just trying to say, let's, we have in law already what a resident is needed to apply for a driver's license or identification card. Again, I think that's the easiest. I would recommend that these individuals get that identification card as well too. And if they had that, then that is all you need as well too. So again, I just think it's important when we're opening up to a population that, we're not seeing this from the surrounding states. And I think that's what's being concerning of what's going, what many of us are seeing right now, and to just make sure that we are truly providing this for, you know, regardless of status, but truly providing this for Maryland residents. And that's the way that we've determined Maryland residents with respect to MVA.
Senator Hayes?
Yeah, so I think the difficulty in like providing any amendments in the reprint is like, I'm not sure how we proceed with them. So when you first started, Patrick, you described the set of amendments. Those were the chair amendments that align it with what the House bill was, right?
That's correct, yes.
All right. And so then we have other amendments that's better than here. These are different amendments from Senator Hershey, and those are on page 2.
You're correct.
Got it. I think, right. And so with this amendment, the Hershey's amendments on page 2, this would apply to not just undocumented citizens, but everybody, right? Anybody that's applying through the exchange will have to now go through this extra level of certification that they are a state resident.
I don't think it's an extra level, it's a different list.
Right, different list,
Yeah,
right.
But
And
yeah,
so-
it would change, you're right.
Right. And I think one of the things that we've worked really hard at doing with this bill is making sure it doesn't have a fiscal note. I think, you know, changing the process would probably require the agency to do something different, meaning it would be a fiscal note attached. These amendments are very similar to the amendments that were introduced in the House and was defeated already. And so I would just ask that we reject these amendments.
Senator Reedy?
Well, can I just, in response to that, or maybe an additional questioning, I definitely understand we don't want to mess up what people are already doing. But we're allowing a group of people who really don't have any real stake or right on doing this. We're going to be asking to allow them to do this. Doesn't it make sense that we would have a process to ensure, because right now there's really not a process. They would just do what everybody else does to prove that they're a resident. But there's not a lot of follow-up on that. I mean, I don't know. I think it makes the bill stronger to make it a little more clear. Is there a way to make an amendment to, and I know that that's not what was in front of us, but is there a way to make an amendment to say that if you have a state issued driver's license, and I mean, is there a way to make it to where we're saying if you're not someone who's already able to use the exchange, you need to be sure to verify that you were legally here, that you're here as a resident for at least 30 days. I think that's what Senator Hirsch is trying to get at. And I'm serious. I think it makes the bill stronger.
Senator Hershey?
Yeah, thank you. And just in response to Senator Hayes, you know, one of the proofs of residency that are in this amendment is a government issued photo identification. So again, that seems to be the easiest one. And I think if you talk to the exchange, the one, and that's even included in their list of what they have, you know, the one that most people are going to be able to bring and utilize very easily. So I don't know that I would necessarily agree that this adds anything to a fiscal note on it. I think it just, you know, again, as my colleague says, it strengthens it to make sure that we are truly talking about residents of Maryland. And, you know, again, that's what this bill is aimed at. You know, we're not trying to go to surrounding states and say, hey, come to Maryland because, you know, if you can find a document that might be in there, or if you can produce something, it's simply, if you're a resident of Maryland, you know, we are going to change policy and we're going to allow you to buy health insurance.
I just think that what the exchange has been doing to document the people who live in the state has been working for the exchange, and including the electronic check that they do when they look at tax returns. That was one of the things. So I hate to just muddy the system that's been working so well. I'm going to go to Senator Lamb.
I think I just wanted to kind of follow up on some points that were made earlier that seem to contend that these folks that are getting health insurance through the exchange or potentially getting health insurance through the exchange have not had any stake in the state. They have oftentimes have jobs. They've been paying taxes in the state. Over $200 million in taxes are being paid in the state. And so you know, I just am very skeptical that people would be moving from other states into Maryland just to be able to buy healthcare at full price. And so, you know, I think this is a very common sense program to allow people to be able to register on the state's health exchange, get health insurance, which would ultimately lower the cost for all premium holders across the board for everyone.
Thank you, Senator. Senator Washington,
I think my question's already been answered.
Senator Mounts.
Yeah, I'd like to add my 2 cents about clarifying whether the individuals are actually actual residents. I know the health exchange has its program, but if they don't qualify, or they don't have the information through whatever checks have been used, those checks have been used for people who are residents. I mean, currently, because the individuals we're talking about right now don't qualify. So I think there's a reason to be a little concerned that, well, if those checks that are in place are reliable, well, yeah, they're reliable, but they've been reliable for legal citizens, people here are lawfully documented, however you want to describe that. And then adding something that's already used in MBA, which has proven to be efficient. I don't think that's unnecessary. I think it's a positive suggestion that would carry on. I mean, it's just a good thing to do.
I think we're going to vote on, Senator Hershey.
If I might just ask another question, and I'm trying to go through the bill as we're looking, but are there any reporting requirements in this legislation to let us know, for instance, how many individuals have signed up in this manner? You know, there might be able to put some of us at a little bit of ease to know, you know, is the expectation that we're going to get hundreds of people or tens of thousands of people? And is there any way for there to be any type of, I know we're not talking about necessarily individual names, but just some type of reporting to see, you know, one, see if this is effective or not, or 2, to really see the types of documentation that individuals are using to do this.
I think that we can ask those questions of the health exchange at any given time. They're readily able to tell us how many people they insure, you know, the ages. They're really good about producing whatever data that we need. So whether, I don't know if it's in the bill or not, but you can always ask Miss Everly and she'll be able to answer that. I mean, they had to re-enroll a lot of people this year. It was a difficult year. So I think after COVID, so I'm really reluctant to make any amendments on this bill because it's going to take us through a different process of concurrence and could be a problem.
I can go again. All right. Madam Chair, I'm looking at it, might not have the votes to get this amendment passed, but I would appreciate taking you up on the ability to continue to communicate with the exchange, and let's see if we can, you know, maybe not necessarily through legislation, but through the request of the chair to ask for information on, you know, what type of enrollment they're seeing based on this specifically each year, and maybe we can make decisions, if necessary, decisions down the road.
We'll follow up with a letter just asking that they track that. You can do that.
I appreciate it.
After
Thank you.
session ends and you can get your breath.
Thank you.
Senator Reedy.
I have a separate question, so I assume you want to adopt the amendments before us. So I just have a question right after that on a separate issue.
Do we want to take a vote on the Hershey amendment?
You want to withdraw it?
Thank you.
Let's see if we get an,
Thank
we
you,
might get an
Your
opportunity. We might get an opportunity to vote on it another time.
So, let's do a motion on the bill with the amendments that came from the House, if we can. You haven't,
So moved, Madam Chair.
okay, and a second, Senator Ellis. Now
Okay.
we have questions.
Thank you. So just one other thing, not trying to get, this is separate from verifying that someone lives here. What measure is in place to determine that we're dealing with a population of people that what measures are in place to determine who they are, who they say they are? That's the same as we determine anybody is, correct, with the exchange. So if somebody says I'm Justin Reedy and I would help, there's a process to determine that I am, to the best of our ability, who I say I am. I understand they're buying full price health insurance, so it's unlikely somebody's going to scam their way into doing that, probably. What is there any safeguard or mechanism to say, what if they're somebody who has a detainer with ICE? We've recently had some situations in Maryland with some pretty bad crimes where some of our county governments have let people go repeatedly and they turn out to have committed a violent crime. And I know this is not the Judicial Proceedings Committee, but is there any, there's nothing in the bill that talks about checking that, because we don't check criminal records when someone buys health insurance. Is that fair to say?
That's right.
Yeah.
Okay. But we also, most people are not, taking advantage of something that we don't normally give to them. So, okay. I guess my question would be, all right, but so there's nothing, it's the bill is silent on that. It does say you can't be incarcerated to get these benefits. How does the exchange know that somebody is or is not incarcerated?
They're checking the addresses electronically
Yeah.
through the system that they have the check.
So if someone is incarcerated and they try to sign up for, somebody tries to sign them up for health insurance using their family's address, it still checks out that they can't get insurance. I understand someone who's incarcerated doesn't need health insurance,
I was going to say.
but I'm asking more for how the process would work. I'm concerned about I'm concerned about that issue, but it sounds to me like there's really nothing that there's no background check that's done when you try to get health insurance, nor would we suggest that there be one. But there's nothing that would allow us to know if someone's that's not here legally that's also wanted by ICE, because ICE puts detainers on folks not just because they're illegally, because of serious crimes. So there's
So,
nothing in the bill
Senator,
about that.
Let me pose this question to you. If I'm here illegally and I've committed a crime and I don't want to be caught for the government, why would I apply for a benefit that checks my residency and my identification?
Well, when maybe you've been let go multiple times by one of the largest counties in our state, and so you might not think that that did check. But I appreciate, I understand. Thank you very much.
Senator Hayes, did you have a
Yeah,
question? or comment?
I know we had went past this when Senator Hershey brought it up, but the last part of the bill, as I was reading it, there are some reporting already in here, so I know we didn't really answer it. We said we'll follow up on it, but it is some reporting in the bill.
Okay, so we have a motion and a second. Let's take a roll call vote, Madam Clerk.
Senate Bill 705 favorable as amended. Vice Chair Klausmeier.
Yes.
Yes. Senator Kramer.
Yes.
Yes. Senator Hayes.
Yes.
Yes. Senator Reedy.
Yes.
No. Senator Ellis.
Yes.
Yes. Senator Mouts.
No.
No. Senator Washington.
Yes.
Yes. Senator Guile.
Yes.
Yes. Senator Lamb.
Yes.
Yes. Senator Hershey.
No.
No. Madam Chair.
Yes,
Yes.
so that's
Eight-
8-3. Thank you. Okay. So now we're gonna go
Okay.
back. Patrick's gonna go back and on Senate Bill 539, it's the sale and resale of tickets, Senator Giles.
39. So this is a bill that establishes consumer protections and disclosure requirements relating to the sale and resale of tickets. Senator Guile has some amendments that are reflected in a reprint, and I can use that to walk through the bill and identify some of the amendments that she was offering. So just for a refresher, this is a bill that establishes certain protections relating to the sale and resale. And so there's some definitions in here of a ticket issuer. So what the First Amendment does on page 2 is it exempts from the definition of a ticket issuer under the bill a sports team participating in an entertainment event or a sports league whose teams are participating in an entertainment event. And then on page 3 of 5, this is, and under subsection B, this is a provision that requires that establishes certain price disclosure requirements So what the amendment does is it says it doesn't apply to a ticket sold for an event held at a venue at which at least half of events held within the prior 12 months were sports events. Under this part of the bill, the listing for a ticket and each step of a transaction to purchase a ticket has to clearly and conspicuously disclose the total price of the ticket, including all fees and taxes, provide an itemized listing of all charges that comprise the total price of the ticket, including fees and taxes, and identify the seat number and zone or section of the ticket to the extent applicable to the seat and venue. And this provision below, yes.
We have questions as we're going.
Yeah, I think so, because it'll be easier if you ask as we go, don't you think, Patrick? Okay. You have a question, Senator Kramer?
Thank you,
Okay,
Madam Chair.
you're welcome.
Patrick, just real fast, because I didn't want this to get lost. So you were reading an amendment that it says does not apply to a ticket sold for an event held at which a venue at which at least half of the events, et cetera. Does that address the concerns that were raised by our friends with the Baltimore Ravens, for instance, and the Orioles? Is that correct?
That's my understanding, that aims to address the concerns that they've raised.
Got it.
Page 2, line.
We did share this reprint with Major League Baseball and they came back to us, and with the other sports teams, and they came back to us that they have no objection to it.
Got it. Thank you.
Senator Gowell, can I ask a question? We
Yes.
know at Raven Stadium, sometimes they'll have Billy Joel or some big entertainer. So this would also apply to those events.
Exactly.
Thank you.
Yes, and good. Yep.
Instead of taking it out, do they now support the bill? When you said that they, the sporting teams didn't have any objections to, I guess, eliminating it.
They came with favorable with amendments is my recollection
And that was
anyway.
their amendment.
And so, I mean, what we're doing here is effectively completely taking them out. Obviously, we just got this back, and it's my understanding is well, we can do this later. I don't know when you wanted to, but I think it probably be appropriately prudent to hold this maybe until another day. But we did share it also with the Ravens, and we haven't heard back from them yet, but I know we did hear back from Major League Baseball.
Gotcha. Okay, thank you.
I should have started with this, Senator. We are reviewing the amendments and then we're going to hold the bill to the next voting session, which may be Tuesday.
I believe that's fine.
Okay.
Thank you.
Yes.
I just want to make sure I qualify what you said, when you said it doesn't apply, meaning this language excludes sports stadiums as long as they have less than the amount of events that they would have for the normal use of their team. So for instance, the Ravens, let's say, have 10 football games a year. As long as it's less than that, then it excludes them from the bill, right? That's what we're seeing.
Sounds like at least half of the events held were sports events. So it sounds like they could have, if they have 10 home games, they could have 5 concerts. That's how I interpret it.
Right, and remain excluded.
Yeah, and remain. excluded.
Correct. Okay, that's what I wanted to make sure. Thank you.
Thank you.
Where was the half part that you were referring to? Okay, does not apply.
So they have to have more sports events than they do
Got
concerts.
it, concerts,
Okay.
got it. Okay, okay.
All right. Patrick?
So the next provision.
Can I ask one question about that? Sorry. How many concerts does M&T Bank Stadium have right now?
I think they may have had 2 this past year.
So they don't have many.
They don't have a limit.
I didn't know. That's fine. I mean, I know if Taylor Swift's coming to town, they're probably doing it there, but they're not doing it there for some of the bands I listen to probably aren't performing there. Gotcha. Okay.
Okay.
So the next provision prohibits a ticket issuer or a secondary ticket exchange from charging a total cost that's different from the amount that's disclosed in this ticket listing. The third thing that the bill does is it under this subsection D here is that it caps the amount at which a reseller may sell or offer to sell a ticket. It can't exceed the total price of the initial ticket on resale. And the amendment here
Yes.
Do we know how the total price, because it says the total price of an initial ticket is determined? Let's just, for instance, talk about the Ravens. A lot of times, in order to have season tickets, you'd have to own a PSL, personal seat license. Is that cost included in the price of the initial ticket? I mean, it should be, because I couldn't buy my season tickets unless I had previously purchased that PSL.
So the amendments take the sports teams out, so those season tickets wouldn't be subject to the requirements of the bill.
Wow. Thank you. Yes, I'm sure.
Senator Guile over there.
I could feel those eyes too. Thank you both.
Okay. Moving to page 4 of the reprint, this is a provision that caps the fee that a secondary ticket exchange can charge for the service of providing a marketplace for the resale of tickets. The cap is 10% of the total price of the initial ticket, that fee. And then subsection F, here, this prohibits a person from prohibiting or restricting the transfer or resale of a ticket that was made available to the general public for purchase. And I believe that this is one provision that may be subject to change. Am I correct?
You're correct, yes.
Okay. So then this next provision here prohibits the sale or offer of speculative tickets. And if you just may recall, a speculative ticket is defined in statute now, and it's a ticket that is not in the actual or constructive possession of a reseller at the time of sale. And then the last couple provisions in the bill on page 5, one prohibits a secondary ticket exchange from providing a marketplace for the resale of a ticket that violates this section of the law. And then the amendment here at the end says that the bill may not be construed to apply to a ticket sold for an event taking place outside the state.
May I ask where the enforcement is for this bill?
The enforcement, this would be a violation of the Consumer Protection Act and subject to its civil and criminal penalties. And so the Attorney General's Consumer Protection Division would have the responsibility of enforcing it.
Okay, do we have any other questions on the amendments, on this bill, on the amendments?
I'm
All
sure I
right,
have
so
a
we're gonna hold this bill until probably Tuesday. I can't guarantee, but we'll probably have a voting. You'll know ahead of time, but so we'll hold it. There might be another amendment sponsor. Senator Guile? Okay. Thank you. We will move on to Senate Bill 541, another Senator Guile bill.
Okay. So this is a pretty comprehensive data, online data privacy bill. And so what I've got here is a reprint that I can walk through that shows some of the amendments that have been requested that the sponsor, Senator Guile, is accepting. And but just to give an overview, this establishes online data transparency, disclosure obligations, and consumer rights concerning personal information controlled or processed by certain business entities, ones that conduct business here or provide services targeted to consumers here that meet certain thresholds and trigger the applicability of the bill. So, going to page 2, we have a lot of defined terms, and so so some of the amendments address some terms that need to be tweaked and narrowed. So here's a definition of affiliate. The Office of Attorney General suggested a different definition that tightens the definition of affiliate, and that's reflected here. You can go through the bill, maybe to the next page. there's a definition of biometric data in the bill. Page 4, there's a definition of consumer health data. There are some specific protections relating to consumer health data under the bill. And there's a change in terminology here so that we're using the term gender affirming treatment, which I think is defined elsewhere like that statute. A number of the definitions here are being amended to align with other definitions in the code. There's a provision here that changes the definition of this federal act, COPA. This is the federal online. This is the federal law that has some protections against getting personal information from children under the age of 13. Just continuing on page 6, some additional definitional changes. One for de-identified data, gender affirming treatment, genetic data, to align with the existing code definitions. On page 7, we've got no changes there, but I do want to highlight that what we're talking about here is personal data. Throughout the bill, these were the protections attached, and that's defined as anything that's linked or can be reasonably linked to an identified or identifiable consumer, and it doesn't include de-identified data or publicly available information. Yeah.
Sorry. Looking at page 6, you were saying you was changing the definitions were changing, but it looked like they're just completely eliminated. Do we find a new definition somewhere else?
Yeah, so I mean, you actually have to go all the way to the bottom of the struck language.
Okay.
You know, and you'll see that the definition has the meaning stated in
the code. Gotcha.
In the code,
Okay.
yeah.
Got it. Thanks.
I think maybe we're on page 8 of the reprint. So there's a change in the definition of precise geolocation data. There's a change in the definition of publicly available information, which is not subject to the protections in the act. And there were some folks who came back who said that the existing definition in the bill was too broad, and so it's been narrowed here to capture less information. On page 9, there's a definition of reproductive or sexual health care. This is a definition that aligns with a definition used in Connecticut's privacy law. Again, there are special protections for consumer health data and sensitive data, which includes reproductive or sexual health care. And so all what's included in that is listed here. The sale of personal data is defined, and that's defined to mean the exchange of personal data by a controller, a processor, or an affiliate of a controller or processor to a third party for monetary or other valuable consideration. And so when the bill uses the term controller, this means a person that alone or jointly with others determines the purpose and means of processing personal data. So you'll see that term used a lot, but I just wanted to make sure that was clear that that's what that's referring to. On page 10, we've got more changes to the definition of sale of personal data, so that it does not include the disclosure or transfer of personal data to an affiliate of the controller. And then sensitive data is defined. Take note of sensitive data, because there are special protections for sensitive data, like the prohibition on sale period. And you can see some of the categories of information that gets that special protection that's listed here. Consumer health data, for example, is listed there. Targeted advertising, there's a definition of targeted advertising in the bill, and there's a change to that. So that what that means is displaying advertisements to a consumer on a device identified by a unique identifier, where the advertisement is selected based on personal data obtained or inferred from the consumer's activities over time and across non-affiliated websites. Some additional changes to targeted advertising here. It doesn't include advertisements based on the context in which it doesn't include advertisements based on the context of a consumer's current search query, visit to a website, or online application. So when you get to page 12, we're through the definitions. This is a provision that establishes applicability thresholds in the bill. And I think a modification was needed here to make clear that this applies to a person that conducts business in the state or provides services or products that are targeted to residents of the state and during the immediately preceding year for both of these categories, controlled or processed the data of at least 35,000 consumers, or controlled or processed the personal data of at least 10,000 consumers. So some clarification was needed there. The next section, these are the entities and information that are exempt from the bill. So you'll see that a regulatory, administrative, advisory, executive, appointive, legislative, judicial body, and this is, or instrumentality of the state would be exempt. I think that was a request from the treasurer relating to the 529 plans and wanting that clarification. This is an important exemption that's of interest to a few. It's an exemption for a financial institution, and with the amendment, or an affiliate or a financial institution or data that is subject to the federal Graham-Leach-Bliley Act and regulations adopted under that act. So this is so financial institutions include insurers, and so this is an exemption that this modification, including data, was something that was requested by these folks. On page 13, you'll see additional information that's exempted, protected health information under HIPAA. Other categories. One thing I will note is that there have been some requests for an exemption that would carve out entities that are subject to HIPAA and protections as opposed to the information. And so this is limited to the protected health information under HIPAA.
Can I ask a question?
Sure.
So with Graham-Leach-Bliley, we protected the bank, the whole entity. But in this, we're only protecting the data, not the entity.
Right.
Okay, but there is an amendment being drafted or considered, or?
I think an amendment has been requested.
Okay.
So yes, that's one amendment that the Insurance Administration has come forward seeking,
Okay.
for covered entities under HIPAA. But those are not reflected in the reprint, and I think if
Okay, thank you.
down below, there's, this is interesting. So there's an exemption for information collected, used, or disclosed by an entity if it collects information, if it's not subject to HIPAA, but it collects information that's like the kind of protected information that's protected under HIPAA. So I think there actually are some healthcare providers like concierge medicine providers who don't bill insurance, and they're actually not subject to HIPAA, but they protect data like protecting HIPAA data. So there's an exemption for that type of information. Continuing on to page 14, this is 144604. There are special protections under the bill for consumer health data. An employer or contractor, a person cannot provide an employee or a contractor access to consumer health data unless the employer or contractor is subject to a contractual or statutory duty of confidentiality, or if confidentiality is required as a condition of employment of the employee. There's special protections for the use of geofencing. This is technology that establishes a virtual geographic boundary or something in this language around an area. And this language, the amendments here reflect some changes to align this bill more like what Connecticut had adopted. So you can't use a geofence to establish a virtual boundary that is within 1,750 feet of any mental health facility or reproductive or sexual health facility for the purpose of identifying, tracking, collecting data from, or sending any notification to a consumer regarding the consumer's health data. 144605 is where a number of consumer rights are established under the bill. There's a right to confirm whether the controller is processing personal data, It gives the right to access the data, correct it, delete it, copy it. It gives the bill on page 16 gives a consumer the right to obtain a list of the categories of third parties to which personal data has been disclosed. And then this is I think one of worth noting. The bill gives a right to opt out, a consumer the right to opt out of the processing of personal data for the purposes of targeted advertising, the sale of personal data, or profiling in furtherance of solely automated decisions that produce legally or similarly significant effects concerning the consumer. So there are opt-out rights here. A controller must establish the method for a consumer to exercise these rights, and that's specified below here on page 16. On page 17, a controller must respond to a request within 45 days, a consumer request within 45 days. Amendments would strike an additional requirement on a controller to notify a consumer that they've complied with the request. Below, if a controller doesn't comply with the request, they have to provide a justification and a right to appeal. On page 18, there are provisions that specify how controllers are to comply with consumer requests under certain scenarios, which are listed here under the bill. At the bottom of here, this is where the bill requires the establishment of an appeal process and requirements for that. On page 19, if an appeal is denied, a controller must provide a mechanism to submit a complaint to the Office of the Attorney General's Consumer Protection Division. This section 144606 provides for the use of an app that enables the consumer to opt out of processing of their data generally. A controller has to, if this is used, a controller has to comply with an opt-out request received from this authorized agent. If using commercially reasonable efforts, the controller is able to authenticate the identity of the consumer and the authorized agent's authority to act on the consumer's behalf. On 144607, this is where we have prohibited conduct by controllers and processors. The amendment, the bill is introduced, restricts these prohibitions to a controller, but the amendments here would extend that to processors as well. The first one here, this would prohibit collecting personal data for the sole purpose of content personalization or marketing without the consent of the consumer whose personal data is collected. In other words, the consumer has to opt in to content personalization and marketing under this provision of the bill. On the next page, or on page 20, there's a prohibition on collecting or processing or the sale or sharing of sensitive data unless strictly necessary to provide a requested product or service. There's a full-out ban on the sale of sensitive data. There are some special protections for kids that are in these items 5 and 6, and so under these provisions, a controller can't process the personal data of a consumer for the purposes of targeted advertising if the controller knew or should have known that the consumer is under the age of 18. And a controller can't sell the personal data of a consumer without the consumer's consent if the controller knew or should have known that the consumer is under the age of 18. So there's some additional protections below regarding the collection, processing, or transfer of data for individuals relating to certain protected classifications. I'll go to page 21. A controller, unless a controller, this provision says that unless the controller obtains the consumer's consent, they can't process personal data for a purpose that is neither reasonably necessary nor compatible with the disclosed purposes for which the personal data is processed and as disclosed to the consumer. There's certain affirmative obligations on controllers and processors. They have to limit the collection of personal data to what is reasonably necessary and proportionate to provide or maintain a specific product or service requested by the consumer. They also have to implement and maintain reasonable administrative, technical, and physical data security practices to protect confidentiality, integrity, and accessibility. There's some other obligations here. If a consumer revokes consent, the controller has to stop processing the consumer's personal data as soon as practicable, the amendment here, but not later than 30 days after receiving the request. Here below is a provision that relates to loyalty programs. This says that the bill can't be construed to prohibit a controller from offering a different price, rate, level, quality, or selection of goods or services to a consumer, including offering goods or services for no fee if the offering is in connection with the consumer's voluntary participation in a bona fide loyalty rewards, premium features, discounts, or club card program. Below is a provision that requires the provision of a privacy notice that includes certain information listed here. The categories of personal data processed, including sensitive data, categories of third parties, with which the controller shares personal data. If a controller sells personal data to a third party for targeted advertising or profiling, the controller must disclose this and the manner in which the consumer may opt out of this. And that's on subsection E. Going on to page 23, this specifies how controllers can meet the requirement to provide an option to opt out of the processing of their data. I think continuing on to page 24 of the reprint, there's an amendment here which says that a controller that recognizes signals approved by other states, these opt-out signals, if these are signals that are approved by other states, they shall be considered in compliance with these requirements under the bill. Below in 144608, there are compliance requirements when controllers use processors to process personal data. I guess when they farm out, these responsibilities to another entity, and their specifications for what that contract must include. Clarifying amendment here. Continuing on to page 25, what must be included in the contract between these entities. On page 26, this amendment would strike a requirement that was viewed as too prescriptive relating to this arrangement between controllers and processors. Below on 26, these are provisions that establish specific requirements on processors. There's I think a drafting clarification here, which is what that amendment is. On page 27, in this 144609, that's in the middle of the page, this is a requirement on third parties. If a third party uses or shares a consumer's information in a manner that's inconsistent with promises made to the consumer at the time the information is collected, this third party must provide the consumer with notice of the new or changed practice before implementing the new or changed practice. Below this, here is a requirement regarding data protection assessment. It's a requirement that a controller conduct and document on a regular basis a data protection assessment for each of the controller's processing activities. I'm on page 28, that present a highlighted risk of harm to a consumer, including an assessment for each algorithm that's used. And on page 29 of 34, you can see that in subsection D, the Consumer Protection Division can require that controller make available to the division a data protection assessment that is relevant to an investigation conducted by the division. In F, if a controller conducts a data protection assessment for the purpose of complying with another applicable law or regulation, that assessment shall be considered to satisfy the requirements established here if it's similar in scope and effect to the data protection assessment that otherwise would be conducted in accordance with this section. In subsection H here, this makes clear that requirement relating to the data protection assessment is prospective in application, not retrospective. And then in 144611, here we have provisions that specify how the bill may be construed. And so that's on page 30. On page 31, Here are more provisions that specify how the bill may be construed. Nothing in this bill may be construed to restrict a controller or process and a controller or process ability to comply with civil or criminal subpoena or summons by a federal, state, local, or other judicial body. You can see that this can't be construed to prevent, detect, protect against, investigate, prosecute those responsible, or otherwise respond to a security incident, identity theft, fraud, harassment, malicious or deceptive activity, or any other type of illegal activity. So if the data is being collected for this type of fraud prevention purpose, what this is saying is that it may not be construed to restrict that ability. And then if you go to 32, nothing here may be construed to restrict an internal use of data. And 33, if a controller or processor processes personal data in accordance with an exemption under this section, that controller or processor has to demonstrate that the processing qualifies for that exemption. On 34, you can see here that violation of the bill is an unfair, abusive, or deceptive trade practice under the Consumer Protection Act and subject to enforcement and penalty provisions under that act, except for the action for damages. That's not one of the enforcement remedies that's available under the bill. And then the amendment here in 4614 establishes a right to cure for the first 18 months that this bill is in effect. And this mirrors some language that's in the Delaware statute. This says that before initiating an action, an enforcement action, the Consumer Protection Division may issue a notice of violation to the controller or processor if the division determines that a cure is possible. If the division issues this notice of violation, then the controller or processor has at least 60 days to cure the violation after receipt of the notice. And if they don't cure it within that time frame, then they can bring an action. There's certain factors that they need to consider when determining whether to grant this opportunity to cure, and you can see them listed here. The last thing I'll note is in the very end, it delays the effective date by 1 year to October 1st, 2025.
Yay, Patrick.
We had to explain the detail more.
Senator Kramer, you have a question?
My question was for the bill sponsor, Madam Chair. What does this bill do?
I was literally gonna kind of ask that question.
So,
We're holding it till at least Tuesday.
and I have received some amendments already from Senator Hershey, Senator Hayes. Yeah, I guess the request is maybe to get amendments in a little bit ahead of time from the next voting session, so I have a chance to look them over.
So Patrick, tell me what you prefer. When do you want the amendments and when should we schedule voting again?
So if the next voting session is
Well,
Tuesday,
it could be Tuesday, but it doesn't have to be.
yeah.
I'm just thinking floor time, you know.
I defer to Madam Chair, but I mean, I know that there is an eagerness at least in order to get moving.
Yes.
So maybe have the amendments, if possible, by close of business Monday.
Okay. And then we maybe could schedule Tuesday after session, after committee voting. Okay, so please have any amendments by close of day on Monday. Okay,
But for voting, it's fine. Right. Yeah, exactly.
Senator Hayes. I'm sorry.
We look alike.
I know. Your brother from another month. Senator Reed.
Ebony and Ivory, that's right. So on that last set of amendments dealing with curing the bill, I just want to be sure I understand. And then I have maybe a broader question, but we're putting in a right to cure. It says on any alleged violation occurs on or before April of 2027. That's what you mean by an 18-month right to
Right.
cure. So if anything happens after 2027, is that where the language below applies about the division issues a notice of violation? Or this is all about before April 2027?
It's a time limited right to cure.
Why are we not having a right to cure more permanently?
Cause you should have figured it out.
Or sorry, I mean, yeah.
You know, if I may, there was also a concern of, let's say, once your personal data is out there, what exactly are you curing? You know, once it's out there, like are you gonna get that back? Like what happens? So we're saying that, okay, listen, for you know, at least for when you consider some Maryland smaller companies, right, that may not be operating nationally, because the reality is that I would posit that some of these larger companies are certainly complying already with data privacy if they're
To
operating
some extent.
nationally, if they're operating, you know, internationally. So so we wanted to at least give some time for these smaller companies or these like in-state companies in order to get up to speed. And that's also why the delay on the effective date is to give them an opportunity to catch up. You know, and let's put the right to cure in place, give people an opportunity, give companies an opportunity to comply. And then to the extent that there's a need to look back later and extend that sunset, by all means, future times. But I think that right now, I think it's important to have that sunset in there.
You make a good point of the data. That is good. So basically, anybody who's doing business in the state now has until 2027. Well, they have until, I mean, theoretically, we'd like it to do sooner, but they have until then to be able to cure. And if someone's coming into business later than that, then they just need to factor in what the law is as they prepare whatever data stuff they're doing. Can I ask a broader question? It could be for you, possibly. What are we really trying to get out of this bill? And I'm not trying to be funny.
Yeah, no.
I'm not against protecting data. It's just, this is a massive bill, which we now are going to have plenty of time to look at the amendments. But
yeah.
But we're trying to protect people's personal data.
Right. And there's also sensitive data as well. So there's you know, increased protections for sensitive data, but there's I mean, look, there's the GDPR that's in Europe that's already has strong data privacy protections that's already existing right now in the US. We don't have we don't have any sort of federal data privacy protection.
And if we wait for that,
and there's countless examples when you give personal data to companies, you know, whether it be online, whether it be apps, whether other venues that ultimately that they're selling personal data.
Well, why does it take such a big bill to say you can't sell personal data?
Good question. I mean, this bill was modeled after other states. There's some things that we took a lot of components from other states. It's because it's just so complex. Technology is just so incredibly complex, and like working with the concept of what a controller is, a concept of what a processor is. There's all these sort of, you know, what geofencing means. So all these types of highly technical terms do require a lot of definitions. There's also, it spells out various consumer protections as what, you know, you have a right to access it, a right to change it, a right to delete it. Also a process of requiring companies in order to do an assessment of what kind of protections that they have in place. So, yeah.
That's how it gets.
In short, it's a big complex issue. If we were able to put it all on one page, like protect personal data, you know, but it's a complex issue.
Okay. Cause I was, okay, that's great. There was a couple of people have brought some concerns that are specific that
I'm sure they did.
We can talk. No, I mean, I mean, I'm just saying, like, I think a lot of it's in some of these amendments, and then maybe a couple will consider. So,
and if I could, Madam Chair, I just really wanted to thank Patrick. Ever since we had the hearing, Delegate Love and I met with him on several occasions in order to go through this. I mean, as I've said before in the hearing, and then even in the aftermath, and I'm sure you've been contacted by other folks, a lot of requests for amendments, and we took even more amendments than what we originally did. And Patrick has been just so incredibly helpful. I'm just so grateful.
Thank you, Patrick.
Thank you.
So we're going to go a little step further. There's some amendments that have been requested that Patrick is going to review with us so we can think about them between now and Tuesday. So Patrick.
So the first amendment is one being offered by Senator Klausmeier. And what this amendment would do would exempt from the bill a nonprofit controller that processes or shares personal data solely for the purposes of assisting law enforcement agencies in investigating criminal or fraudulent acts relating to insurance or first responders in responding to catastrophic events. I think this organization called the National Insurance Crime Bureau is specifically interested in having this type of exemption. The second amendment offered by Senator Hayes exempts from the bill a provider of broadcast television service, cable service, satellite service, streaming media service, or other service offering video programming described in this Federal Communications Act. And then the third amendment being requested by Senator Hershey would strike and this one is actually shown on the reprint so you can see what it's striking on page 2 here. And this strikes the prohibition on collecting personal data for the sole purpose of content personalization or marketing without the consent of the consumer. So this amendment would take that prohibition out of the bill.
Changes it from opt-in to opt-out. Right, and it's not as complicated as it looks, it's just a couple lines, but you had to read them.
Correct.
Just the Verizon amendment.
And what did we have to opt out of, Patrick, as opposed to opting in?
The collection of personal data for the sole purpose of content personalization or marketing.
So you're saying the bill right now says that the only way this information is collected is if you opt in to have it collected. Is that correct?
The consumer needs to provide consent for that collection.
And under this amendment, we're now taking it from the consumer, making the choice to agree to have this personal information collected, to the consumer now has to say, I don't want it.
It's specifically for content presentation, so, right, just content presentation. So it would leave it exactly the way that it is now, that when you're going through your experience of being online and you start to see things that feel like they're targeted more towards you, it would leave it that way unless you said, I don't want you to use my data for that. And then you would say, I don't like that. I want to see all the crazy information that's out there come to mind. So this would just say, leave that part the way that it is now. And rather than having to click on something every single time you get on there and say, I don't, I do want to see this rather than not see it. And so it just changes that one part.
Under the context of this amendment, you would, so right now, in other words, it will prohibit that from happening unless on each and every one I say, I want this to be done. Is that correct? The way, listening to your explanation, I'm trying to get a handle on that. The question I have is, are we shifting a burden to the consumer
Trying to fix that.
to protect their data, or are we improving?
If you think getting bombarded with a lot of information that is not personalized to you is an improved experience, then
I don't want that.
Right, and I don't think anybody does. I think what we'd all rather see is that the content personalization is geared towards us as individuals. So what we'd like to do is keep it that way unless you decided to opt out of it. Then you would opt in. Right now, it says you have to opt in
In order to get
yes,
advertising.
right. You'd have to opt in to get it the way the bill's written now.
And I don't want to opt in to get it. I don't want any of it.
Well, then you would.
Well, wait.
Advertising to me, correct?
No.
I don't know what you want, but I would think that you would want, I don't know that you want information that's not targeted to you. I don't know what value that has.
Thank you. And that's one of the things I was gonna add,
Right.
Yeah, we complain, we look up a pair of shoes and then we get 15 ads about shoes, but I'd rather have that than 15 ads about wrestling clothes or
Right.
something.
Right.
Do you know, I
Right.
mean, I'd rather get ads about things that I'm interested in and not just anything somebody feels like sending me.
Correct.
And it's gonna happen. I mean, internet advertising's cheap. We're gonna continue to get ads. Do we want ones that we like or ones that we don't care about? Just something to think about.
I shall think on it.
Senator Hayes?
What?
Oh, I do. I'm sorry. I was gonna describe what Hershey already took care of it. And so the amendment that I have, Patrick, depending on the success of the amendment Hershey put forth, wouldn't be needed.
I think your amendment's different. I think
Oh,
it's
gotcha.
it's
Okay.
exempting, it's
All right.
exempting
Never
a service
Got it.
provider from the
Got
bill.
Okay.
Gonna discuss these amendments now, or do you want to wait until next? I assume you want to wait until next week, the amendments that we have before us right now.
Well, I think give people time.
Yeah. Okay,
Is that
that's,
okay?
yeah, that sounds good. I just wanted to make sure. I know we're discussing some of the amendments right now, including the one Hershey put forth. So I didn't know if you wanted to discuss
Are
all
there-
these amendments right now that we have, or if you wanted
Did
to
we
wait
just
until
discuss them?
next week.
I thought we already discussed them. Did I miss something?
Well, I did want to ask one question, if I may, about the Klausmeyer amendment.
Madam Sponsor, you can ask any question.
Thank you.
like.
And I really, this is for the education of the committee, but Patrick, maybe that there is a section already that we have in the bill that states that nothing in that bill should apply to, for example, an investigation related to fraud. Right?
Yeah, I think I highlighted that one on page 20. Let's see. So you're referring to page 31 of the reprint.
Right.
And this is the construction of that, that it can't be construed to prevent the collection of data for to respond to a security incident, identity theft, fraud, harassment, malicious or deceptive activity, or any other type of illegal activity.
Okay,
Yeah.
so just, consequently, it's potentially that this Klausmeyer amendment may be redundant. You don't have to, yeah. I would argue at the very least. I guess, Patrick, you don't have to respond, but all right, thank you.
Any other questions about these amendments? And I'm sure there'll be more on Tuesday. Okay. Thank you, Patrick. Are we
I
gonna?
mean, do you want an answer to the question?
Yeah, is it redundant?
I think that it's similar to the question we've been having about whether you exempt an entity or you exempt, the type of information. So the activity. So there may be a difference, but it's, this exempt from the act and this type of entity, this nonprofit controller that processes or shares personal data for these purposes. That's the distinction I would make.
I have one other question. Did the MIA, did the MIA give us any amendments?
Yes, they do. The MIA has identified three things that they're interested in the bill, of which one is reflected in the reprint here, which is the Graham Leach Liley amendment. But there are a couple too. There's a reference to insurance in the bill that they want out. And they're also interested in that entity level exemption for entities subject to the privacy rule under HIPAA.
And Patrick,
Right, they
go
wanna
ahead.
get rid of the HIPAA stuff, right?
No, they don't want to get rid of it. They want
They
to
wanna-
make it broader, make it
Right.
broader. Will you have those other amendments from the MIA ready for Tuesday?
Yes.
Thank you. Okay.
So we have one more bill.
You, and we still have David's bills. So you have
Mine.
the code, the Maryland Kids Code, the Consumer Protection for Kids.
So Senator Kramer has some amendments that are being prepared that they're not ready yet. And the amendments do aim to align some of the terminology in his bill with what's in this other bill. I can go ahead and explain this bill now, or we could wait.
Madam Chair, may I suggest it might be prudent to wait until we actually have the amendments for everybody to see, but perhaps an interlineated copy.
Yes, you may suggest.
Yes, you may suggest that.
Patrick needs some hot tea.
Don't mean that she's one.
Should we try to schedule that for Tuesday, Patrick?
Yeah.
Okay, so
Be
we'll
ready.
wait till Tuesday. Thank you, Senator. Finishes your work for today, right? Thank you. And you really have worked hard and we appreciate it. So David, your turn.
We've got more. Madam Chair, real quick, since Patrick's still here, I just want to acknowledge that
Health Benefit Exchange Director, Eberly did respond to me via, did you see it already? Okay,
did.
via
But you,
email.
you can share it with everybody.
Well, that she did hear the voting session and that they do put an awful lot of data together already regarding who enters the exchange, and she thinks that her IT team will be able to get the information that we requested. So thank you to her for listening and responding.
Okay.
We have a few more bills and then at the end of the session, I'm going to make an announcement. So let's finish up with David.
Okay, the next bill on your list is back on your list. This is Senate Bill 244, revisions to the Clean Indoor Air Act. You have a reprint in front of you. And the bill's introduced did four things that conforms the Clean Indoor Air Act with some of the terms that you've done last year with adult use cannabis. It adds vaping to the activity banned in indoor areas. So along with smoking, vaping will no longer be permitted in indoor areas as defined in the bill. It codifies a sign requirement about you may not vape or smoke on these premises. And it strikes outdated waiver provisions that were put in the bill in 2007 that authorized businesses to be waived from the provisions. That's all gone now. Those waivers are no longer allowed. You have a reprint in front of you. And we'll just go straight to page 3. There's an amendment offered by the department. It's a departmental bill. And if you go to the bottom of page 3 of the amendment, you'll see, and this deals with the carve out for retail tobacco businesses that would still allow smoking indoors at a retail tobacco business, as long as the primary activity is the retail sale of tobacco products and accessories, and the sale of other products is incidental. And this is the change, the business does not possess a liquor license for the sale of alcoholic beverages for on-site consumption. So that's one of the amendments to the bill. And then that's on page 3, bottom of page 3 of the reprint. So what it really means is that if you do possess a license for the sale of alcoholic beverages for your retail tobacco business, you would not, this exemption for smoking indoors would not apply to you.
The exemption.
What
can we do if we have a license?
Well, if you have you have to, I guess it's an either or thing. If you have the license to sell alcohol, you will not be exempt from the indoor smoking ban. You can't smoke indoors. So you have to decide what's more important to you, to have the from the health department's point of view, what's more important to the business, to still be allowed to smoke cigars indoors, or to sell alcohol.
Businesses?
This would apply to existing businesses.
Senator Washington, you have a question?
Not on that last point. Yes, I do have when we had the hearing on this bill, there was some conversation about schools and vaping in schools. Can you clarify that, or we didn't? They just mentioned it.
The question was asked, I think, by Senator Mouts, and that's done in a different part of all the boards of education ban smoking,
correct,
and vaping in schools. So that's done. That has not. Technically, it is banned by these laws, but that's dealt with and enforced by the local school boards.
Got it. Thank you.
Senator Hershey?
Madam Chair, going back to that last amendment that we talked about with respect to cigars and alcoholic beverages, I would ask that we don't adopt that amendment. I mean, we do have all the alcoholic beverage bills now. I think that would be a standalone bill that, would have to, because it's related to alcohol, it's related to existing facility, retail locations. It just seems that warrants a bill hearing rather than just a departmental amendment.
It's not really a departmental amendment. It's the chair's amendment.
My apologies for, I just.
Senator
I
Lamb?
just said what-
Yeah, and I appreciate the amendment. I think it is important and it's an issue that this committee has some familiarity with from last year. This is not the first time we've seen or heard this issue. And there have been facilities that have exploited kind of a loophole in the definition of how the original Clean Indoor Air Act was defined, as well as how the department has subsequently viewed the provisions in the statute that have allowed these institutions that are permitting of indoor smoking to also have alcohol, which I think is inconsistent with the spirit of the Clean Indoor Air Act. And so I think this provision is actually really important, and it's an important opportunity just for us to clarify and close a loophole that's really been exploited over the last few years.
There's been a lot of discussion. Thank you, Senator. There's been a lot of discussion about how to handle this. We have 7 licenses in the state that are allowing alcohol and smoking, and some have full bars. And where do we draw the line? Do we, it's like, do we let them continue to operate? Do we let new ones come in? Do it, we passed a bill in 2007 that became effective in 2008 that said we do not smoke and drink alcohol at the same time, indoors. And we're just clarifying it. Senator Hayes?
I'm not sure if we finished discussion on it, but I was going to ask Madam Chair, we could just hold off on this bill.
You're
just for
asking to
today.
hold the bill?
Yes, ma'am.
Yes, sir.
please.
You can hold the bill,
Thank you.
always.
Thank you.
Senator Ellis, haven't heard from you yet.
Yeah, so I'm trying to process this because I think I have one of these, thank you, Madam Chair, one of these facilities in my district. That's very popular. Yeah, so. What's it? Well, at least one I know about. So this would affect several in your district too, Madam Chair?
They're not in my district,
But
they're in my
in the
county.
county,
Yeah.
okay.
I will tell you, it slipped in as incidental. That's how they call it, incidental. And they weren't enforcing this 30% incidental, but then they began to enforce it. I
So-
don't know how complete the enforcement's gonna be, but
Would it be appropriate to ask you that you like this amendment? Oh, it's yours?
Yeah.
I thought it was a departmental.
no, it's not.
It's yours.
It's mine.
Oh, well, okay, well, thank you, okay.
Thank you.
Well, thank you.
Senator Hayes has asked to hold the bill, so we will hold it until the next voting session.
I understood.
Okay. By the way, there's one additional amendment in here, which we should cover now. It's not nearly as interesting as the amendment you just discussed. And if you go to the very last page of the reprint, there's actually Maryland Department of Labor is responsible for enforcing the indoor smoking ban at places of employment. And this makes a slight change to that authorization by striking tobacco and just going with smoke, which is a defined term in the Clean Indoor Air Act. So this would just update their law, the laws they use to enforce indoor smoking at places in the workplace. So that's the last part of the amendments.
We are holding Senate Bill 244, and we're gonna go on to Senate Bill 436, another Senator Gile bill.
Okay. The Senate Bill 436 is similar to a bill that passed the Senate actually last session. As introduced, the bill establishes criminal penalties for violations of the workplace fraud law and the prevailing wage law. And it also would require the Maryland Department of Labor to refer these violations to several entities defined in the bill. You have a reprint in front of you with amendments offered by the sponsor. So if we go to page 2 of the reprint, at the top, you'll see that the criminal penalties are struck from the bill, but the civil penalty is doubled to $10,000. That's the first change offered by the sponsor. If you go to the next page of the reprint, page 3 of 4, in the middle on line 7 and 9, you'll see that there's a max penalty of $20,000 per employee for multiple violations of the workplace fraud law. This ups that to $30,000. And at the bottom of the page, this is the language that requires the department to refer to various entities that they find a violation. That is simplified. And it's actually will be consistent with a bill that came out of here last year. Clear and convincing evidence is struck. And then you go to the next page. And if MDL finds a violation, they can refer it either to the controller for an investigation by the Field Enforcement Bureau and the U.S. Department of Labor. State's Attorney's Office is gone, U.S. Department of Justice is gone, and the U.S. Department of Treasury is gone. At the bottom of the page, the criminal penalty for violations of the prevailing wage law is struck, and the same referral language is put in for violations of the prevailing wage law determined by the Maryland Department of Labor.
Move favorable.
Second, as amended.
Oh, I think we need
Need a chair.
chair and a vice chair.
I'll go up there. How many bills do we have left? Let's take all those whole bills, move unfavorable.
Up to.
Downloaded on there. Yeah. Oh, here too.
I'm sorry.
And
Favorable, Kramer seconded, Senator Kramer
and Senator Meltz has a question.
Senator Mouse.
Yeah, this is about pretty significant bills. What, can I hold this for to the next voting session? Senate Bill 436.
They
Just
didn't
vote
vote, they didn't vote on it.
Oh, they didn't vote on it. Okay.
If we did, it didn't matter.
Okay. I just want you all to be prepared. We're working late tonight. We're gonna work
Yeah.
late
Can
on
I-
Tuesday.
Can I just make a quick comment
Yes,
upon it, Madam Chair? So the question came up really was like, during the testimony, what we heard was this has been a cost of doing business. Whatever these fines are is a cost of doing business. And that's why, that there's companies that are just not complying. And so what we looked at is said, like, when was the last time that these civil penalties have been, when they were first set? And I think from speaking with David, it's been like over a decade, David?
These are the original penalties from the bills that was passed 10 years ago.
And so then we said, okay, well, why don't we say, let's increase the civil penalties, remove the criminal penalties, and say this could potentially be a stronger deterrent. And I would also add, it says up to, for what it's worth. And so just consider it. I know it's being held, but that's my piece. Thank you. Thank you, Madam Chair.
Thank you. So we request to hold Senate Bill 436. Next, we're gonna do Senate Bill 525.
It's getting done. Anyway, die in the house. Okay, the next bill on your list is Senate Bill 525. This deals with the law for equal pay for equal work, and the bill is titled Wage Range Transparency. The bill makes changes to the existing provisions of law regarding the provision of wage ranges upon hiring. The bill, the previous provisions were enacted in 2020, and this expands those provisions. There are amendments offered by the sponsor who worked with the Maryland Department of Labor, and there's also a clarifying amendment, and then there's an amendment from the chair. So you have a reprint in front of you. And on page 2 of the reprint, there's several definitions added, including a definition of wage range. And there's some changes to this definition. This was suggested by the sponsor through the Maryland Department of Labor. So they're basically saying that this would be hourly or salary wages, and it'd be a minimum or maximum for hourly or salary wages. And that's pretty much what they've gone through here on the definition. And you go to the bottom of the page, this begins the actual part of the law that in 2020 regarding dealt with providing a wage range. And you'll see that what's struck on lines 24 and 25 was the original provision. On request, an employer shall provide to an applicant the wage range for the position for which they applied. That is struck and is replaced with, first there's an application piece. And this is designed to apply to remote work in the new economy. And there's an amendment here that goes to the second page. Oh, there's also an amendment offered by the sponsor at the bottom of the page. Instead of all these things like promotion, transfer, and other employment opportunities, it's just simply a position for work that will be physically performed in at least part of the state or outside the state if the employee reports to. And there was some confusion about what supervisor meant here and how this would be applied. So it's simply if the work is performed outside the state, the employee reports directly to or reports to an employer that is physically located in the state. So it has, again, back to what an employer, it has to be a Maryland employer for this part of the bill to apply. We go down next to lines 6 through 15, and this is actually what replaces this part that was struck. The employer shall disclose in each public or internal posting for a position, the wage range and a general description of benefits and other compensation. If the public or internal posting for a position was not made available to an applicant, the position, the employer must disclose to the applicant the information required under the first part of under lines 7 through 10 before a discussion of compensation is held with the applicant and any other time on the request of the applicant. Next, we go down to lines 19 and 20. The employer shall set the wage range disclosed above in good faith, and good faith is a common law term that they have to use their best judgment to develop this wage range. And then there's an amendment offered by the sponsors, and this is from the Maryland Department of Labor. It requires the commissioner to develop and make available to the employers a form that the employer may use to comply with these new requirements. If you go down to the bottom of the page, this is all existing law. This regards anti-retaliation measures for any employee or applicant who exercises their rights under the law. And there's just a few additions here to promote or transfer an employee because you're now beyond just hiring an employee. And if you go to the next page, there's all existing law regarding more retaliation language, anti-retaliation language, and that's all maintained. There's no changes there. At the bottom of the page, it adds additional record keeping requirements relating to the wage range provisions. There are already record keeping requirements under the equal pay for equal work law. Those are above, but this adds specific requirements for wage range provisions. And again, these are amended from the sponsor based on suggestions by the Maryland Department of Labor. On page 5, there was a separate cause of action for violations of the provisions relating to wage ranges that is struck from the bill, and this is from the chair. So you'll see that lines 12 through 15 would have been a new cause of action that's struck, and then 29 through 30 is also struck because that relates to the cause of actions between on lines 12 to 15. And the rest of the law is maintained. There's still the ability for somebody to complain to the commissioner, and there's a series of steps on page 9 or page 6, which there's no changes regarding the steps one can take when if they feel that they've been treated improperly, and they can go to the commissioner instead.
I can't do that. I can't make a motion.
Favorable,
As amended, right?
Right,
as amended.
okay. So Senator Reedy.
On page 3 of the reprint, line 16. Right before line 16, we have that if a public or internal posting for a position was not made available to an applicant for the position, disclose to the applicant the information required to be disclosed. Before a discussion of compensation, that just seems weird to me, like that line before a discussion of compensation is held with the applicant. You're saying you have to, the paragraph above it is saying it's required to be disclosed, or am I misreading that? I'm trying to.
I think the way this is envisioned to work is generally when you advertise for a position, you have to put the wage range out there.
Right.
But in some cases, you may not necessarily advertise for the position. You may try to go internally. So this would also, and in cases where you don't actually advertise for the position, where that information is not out there, or maybe you just decide to hire internally and you're dealing with somebody inside the organization, then if they didn't have access to this information, you would have to give them. Yes, you have to give them that.
But then you
information
also
upfront.
have at any other time on request of the applicant. It's
Yeah.
not, you don't have, but the bill has.
Yes.
So if you've already disclosed it to them, why would they be asking for it again, or? It's just trying to cover all the bases.
I think they're trying to cover all certain circumstances of when the wage rate should be made available.
And then one other thing, on the previous page, we talk about it being the wage range being set in good faith.
Yes.
I certainly think everybody should operate in good faith, but the business. Good faith, is that a
It's a
legal terminology?
common law term.
I know it is, yeah.
And so it just means that when they set their wage, they have to use their best judgment and be, in their best interest to come up with whatever the wage.
We need to put that in law. All right,
It's a judgment call for you all.
okay, thanks.
Senator Land.
Yeah, thank you, Madam Chair. I don't have an issue with these amendments. I just wanted to bring up that I'm also waiting for an amendment. It's just a small amendment that we learned that the underlying equal pay law doesn't apply to race, disability, and sex. And we just wanted to fix that. So I'm waiting on an amendment to come forward. But I'm
bill.
fine if we adopt these amendments soon.
Okay. Senator Mounts.
And does this apply to part-time the same way as it applies to full-time employees?
It applies to anytime you hire an employee.
And what about the visa workers? So we have a lot of farm help on the shore that come in and they're on visa. How are they treated by this?
It's an equal pay for equal work law. So I would imagine that, I don't know how this would apply to visa workers. I was asking, so we don't know whether they're covered or not. We don't know whether they're covered or not. H2A or H2B. Now, H2B is a different category. Those are guest workers that are supposed to be, a lot of them do seafood, but there are a lot of them, in the hotels and stuff like that. Are they covered? It's any employer is covered, but again, I don't know how it works for visa workers.
Do they post those jobs for visa workers? This is about job postings.
I believe they are advertised. I believe.
If they're
but I don't
advertised-
know for certain. I know they come over. This is always a tricky thing. I remember we had to do a carve out on minimum wage. We did minimum wage years back, not the recent one, but the previous one, if you remember that discussion. So I'm not exactly sure. And then I guess I had one other follow-up question, and this applies to all, because I know the Restaurant Association came in to testify and they were opposed. This would apply to all hospitality and regular.
It applies to any employer in Maryland with employees.
Right, right.
Hourly
or salary.
Hourly or salary, yes.
Thank you.
Senator, do you want to check on the carve out question? And if you want an amendment, request an amendment?
I'd like, yes, I'd like.
We're
to do
holding the
that.
bill anyway till Tuesday.
Yeah, I will
so.
check on that.
Also, if the employee is remote work.
Senator Hirsch, you have a question?
Yeah, just want to make sure it's also applies to out of state.
Not out of state employers.
Not out of state. So an out of state employer that hires somebody in Maryland, then it does apply or it does not?
No, it doesn't apply to them because they're out of state. They're not an employer in the state of Maryland.
Okay, even though the job might be in Maryland.
The job might be in Maryland, but
They're a company that's located out of Maryland.
It doesn't apply to them.
Thank you.
We want to adopt the amendments in the bill as that we have now, and then we'll see if we have new amendments on Tuesday. So can I have a motion for the amendments on Senate Bill 525? And is there a second? second. So all in favor of the amendments on 525. That's all it is just the amendments. Senator Washington, you with us? Okay, unanimous on the amendments for 525.
Okay, well, doing well here.
You know, Nathan started off so well.
Okay, the next bill is House Senate Bill 559. It establishes a special fund for the purpose of allowing the Maryland Department of Labor to give them the resources to implement the laws passed several years ago regulating household goods movers.
Second, all in favor of the household movers. It's their fees that they'll pay to register that go into the fund.
Their fees that they're paid.
Yeah, they're paying, they asked for this, the household movers. All right, so Madam Clerk, will you call roll, please?
Senate Bill 559 favorable. Vice Chair Klausmeyer.
Yes.
Yes. Senator Kramer.
Yes.
Yes. Senator Hayes.
Absolutely.
Yes. Senator Reedy.
No.
No. Senator Ellis.
Yes.
Yes. Senator Mount.
So.
No. Senator Washington.
Yes.
Yes. Senator Guile.
Yes.
Yes. Senator Lamb.
Yes.
Yes. Senator Hershey.
No.
No. Madam Chair.
Yes. I
Yes.
would just like to add, this doesn't set the fee. We passed the bill years ago that set the fee. This just puts the fee into the fund. So just want you to know you're not voting for a new fee.
Thank you.
Okay.
Okay. Yeah.
They're still
Go ahead.
They're still paying.
Okay. Okay, one more bill.
You're not going anywhere. You're not allowed to leave the room.
Okay, the final bill is Senate Bill 648. This was up the other day and it was held for an amendment from the sponsor to make it look like the House bill, which is already in the committee. And the bill prohibits a person from serving as a broker between a contractor and subcontractor within 5 years of being convicted of an offense constituting criminal malfeasance, misfeasance, and nonfeasance under federal or state law. The amendment you have in the reprint in front of you also provides this cooling off period to a contractor or a subcontractor.
Motion favorable. We have Senator Hayes and Senator Washington, all in favor of Senate Bill 648. All in favor of Senate Bill, Madam Clerk, please call the roll.
Senate Bill 648 favorable. Vice Chair Klausmeyer.
Yes.
Yes. Senator Kramer.
Yes.
Yes. Senator Hayes. Yes. Senator Reedy.
Who the sponsor
No. Senator Ellis.
Yes.
Yes. Senator Mount. No. Senator Washington. Yes. Senator Guile.
Yes.
Yes. Senator Lamb.
Yes.
Yes. Senator Hershey.
No.
No. Madam Chair.
Yes.
Yes. 8-3.
I guess we're not leaving the room.
No, we're not leaving.
That ends our voting session.
And now what?
Now what? I think our trooper's gonna